Thank you.
SJC-11230, Chambers.
Good morning, Your Honors.
Morning.
May it please the Court, my name is Ken Seeger. I represent Anthony Chambers. Your Honors, this case presents an issue regarding the admissibility of evidence of prior violent conduct of the victim of the case pursuant to Commonwealth versus Adjutant. And I would just like to review what happened procedurally with respect to the trial judge's ruling over this evidence. The trial judge conducted a voir dire of a witness named Ismail Sasa, and Mr. Sasa testified to an assault that he had experienced at the hands of the victim in this manslaughter case, whose name was Edwin Quiles. After the voir dire, the trial judge ruled that the evidence was admissible and counsel would be permitted to present the witness. The trial begins, Commonwealth presents its case, and at the end of the Commonwealth's case, the trial judge issues a ruling essentially reversing her order and rules that, I'm sorry, Your Honor.
Well, I was just trying to get the context. I gather that it came up because the Commonwealth was asking for an adjutant instruction? Or did the Commonwealth ask for him not to testify, Mr. Sasa?
Well, at first there was an objection by the Commonwealth to the testimony of Mr. Sasa, and the judge ruled in favor of the defendant. But later on, there was a request for a jury instruction.
What point in the case was that?
That was just prior to, I'm sorry, Your Honor, when the judge reversed herself?
Yeah.
That was just prior to the point when the Commonwealth rested. So it was right at the end of the Commonwealth's case, prior to resting, and the judge had rules, and the ruling is written on the Commonwealth's request for a jury instruction that there was no evidence, rather there was no issue regarding the identity of the first aggressor in the trial, and there was no evidence that Anthony Chambers was the first aggressor.
Okay, so what kind of jury instruction was the Commonwealth asking for? Was it one where that you would not be basically entitled to press self-defense if you were the first aggressor?
The jury instruction was that, if I recall correctly, Your Honor, that the Commonwealth was requesting an instruction that the testimony of Ismail Sasa would could be considered regarding who the identity of the first aggressor was.
And only that.
Versus adjutant.
And only that. In other words, it shouldn't be to make Mr. The victim a bad person or something like that.
Well, correct, Your Honor. I mean, it was a correct instruction pursuant to
Right.
Commonwealth adjutants, but it would only pertain to that particular issue regarding the identity of the first aggressor.
And so the judge didn't want to give that instruction because she said there's no first aggressor issue here.
That is correct, Your Honor. The judge ruled that Ismail Sasa could not testify. There was no issue regarding the identity of the first aggressor. Therefore, she was not about to give that instruction.
Did the Commonwealth ever concede that there was no question as to the identity of the first aggressor?
I don't believe the Commonwealth ever conceded that, Your Honor. Certainly the Commonwealth objected to the testimony of Mr. Sasa, and the Commonwealth's objection was more predicated on the fact that I believe they were afraid that there were some contradictions in Mr. Sasa's testimony, and they were afraid of a mini-trial, and therefore the judge should rule against the testimony as a matter within her discretion.
But that wasn't the basis for the Commonwealth's objection to Sasa's testimony in the first instance.
I believe it was the basis for the...
That there's no issue as to who the first aggressor was?
Your Honor, I believe the Commonwealth did not concede that. The Commonwealth's objection was based on the idea that the probative value of Mr. Sasa's testimony was outweighed by its prejudicial effect.
And that's not the basis on which the judge ultimately excluded Sasa's testimony.
The judge initially allowed the testimony and found that it was admissible, that it had probative value, but ultimately reversed herself, making the legal ruling that there was no issue regarding the identity of the first aggressor. And that's something that Judge McHugh pointed out in his dissent, in that this was not a discretionary ruling by the trial judge when she excluded the evidence. It was a legal ruling that she had ruled that there was no issue regarding the identity of the first aggressor. And, Your Honor, just getting back to
The judge did have discretion not to permit it.
she did have discretion not to permit it if she had found that the
more
probative
prejudicial.
value was outweighed by its prejudicial effect, or if it would be cumulative, or if it would result in too many collateral issues, but that was not the original ruling. The original ruling was that it would be admissible, but the ultimate ruling was that there was no issue regarding the identity of the first aggressor. I would submit that's a legal ruling that this court should review. And this is why I mentioned the dissent by Judge McHugh, because he pointed that out. And in reliance on that initial ruling, and I'm just getting back to what happened procedurally, defense counsel delivered his opening statement, and he promised the jury that they would hear testimony from this Mr. Sasa, and that they would hear testimony that the victim in the case, Edwin Quiles, was a person who was capable of unprovoked violence. I believe that was the expression that he used. And what I would suggest, Your Honor, when the judge reversed her ruling, her initial ruling, that was an error of law. And certainly there is an issue in this case regarding the identity of the first aggressor. And in the brief, I've pointed out many examples throughout the trial, throughout the testimony, the openings, and way up until the closing statements, exactly why there was an issue regarding the identity of the first aggressor.
It would not be an error if she had given the instruction that the defendant asked.
That's correct, Your Honor. He
Basically, would have said there's no issue here. I'm telling the jury there's no issue here.
Right, and he did ask for that. He actually, Your Honor, presented the trial judge with two alternatives. And the first alternative was simply to reverse herself again and allow Mr. Sasa to testify. And the other option was to provide a jury instruction that there was no issue, that there was no evidence that Anthony Chambers was the first aggressor, and that the testimony of Ismail Sasa was not then necessary. And that was a request he made. And he made it again after the jury instructions.
Could I ask you this? Was the issue that really was the issue so much who started the fight, if you will, as opposed to who took the knife? In other words, who was the first person to use lethal force?
Well, I would suggest, Your Honor, that it's very important to look at the testimony of Mr. Crevells, who was the third roommate in this situation.
And actually the one who had the apartment.
He's the one who actually had the apartment, and he's the only actual recipient witness to this fight.
But
And,
not to all of it, obviously.
I'm sorry?
Not to all of it. He
Not
came in on
to all of it, and that's the key point, because Mr. Crevells heard these two men arguing, and certainly there's no dispute that Mr. Quiles, during that argument, was more aggressive, and Mr. Chambers was passive, no question about it. But Mr. Crevells leaves the apartment, he goes out for a cigarette, he comes back, and when he comes back, these two men are already engaged in what turns out to be a deadly struggle. There's already blood on the floor. Mr. Quiles presumably has already been stabbed. Mr. Crevells doesn't see who started that fight. He doesn't see who threw the first punch. He doesn't see who picked up a knife. He just sees them locked in this struggle. And, very importantly, he sees Anthony Chambers clearly with the upper hand. He's on top of Quiles. He pushes him down onto a bed with his arm over Mr. Quiles' head. And then he hears Mr. Quiles say, "You stabbed me, you stabbed me." Clearly, the jury listening to this testimony would be certainly well warranted in believing that Anthony Chambers was the first aggressor in this incident. And
First aggressor in the sense of using lethal force, or first aggressor in the sense of actually starting it?
may have been the first aggressor in the sense of starting it, and may have been first aggressor in terms of using lethal force.
Because adjutant goes to the just starting it, right? Not who somewhere along the line takes out the knife.
That's how I would interpret adjutants, just by the expression, the first aggressor. And I would point out, Your Honor, that it's very important to review the defendant's statement, which was transcribed and is reproduced in the record appendix. And it's a long statement. Police are questioning him, and they're finding contradictions in his version of the events. And at the very end of the statement, the police essentially, they're accusing him of picking up the knife first. Well, it's a direct accusation. You got fed up with Mr. Quiles, didn't you? You picked up that knife. Isn't that what really happened? And not only, so he's directly being accused of being the first aggressor. And I don't think there's any dispute about that. He's directly being accused, and the Commonwealth in its closing argument continually points to that statement, is drawing out contradictions in Mr. Chambers' version of the events, is pointing out examples of consciousness of guilt, such as leaving the scene, blocking the door to the apartment, cleaning up the bloody mess, and leaving the apartment, not stopping for the police officers when he was first told to stop, lying about blood on his hands. The police asked him, what is that blood on your hands? And he says, oh, it's a cut. Well, that's not true. And the Commonwealth points that out. Why? To establish that Anthony Chambers was the first aggressor. He was lying in his statements. He was lying when he said that he was simply defending himself, and that therefore Mr. Chambers was not entitled to a self-defense claim. And that's why that closing argument reads the way it does by the Commonwealth, that he was not entitled to that self-defense instruction. So I would suggest all those comments in closing argument and examples throughout the trial demonstrate, I would suggest very clearly, that there was very clearly a dispute over who the first aggressor was. And despite the judge's ruling, the way this case went into the jury room, they certainly might have believed that.
What's the legal significance of being the first aggressor?
The legal significance of being the first aggressor would be that Mr. Chambers, if he can establish that Mr. Quiles was the first aggressor, and it goes directly towards his self-defense claim, it simply bolsters his self-defense claim that he was. So
it just bolsters his self. So there's no legal significance in this case. There was no instruction about if someone begins a fight, they can't claim self-defense or something like that.
I know that the jury was instructed on the elements of self-defense and the Commonwealth's burden of proof with respect to self-defense, but this just goes towards prejudice because the judge's ruling took away the one witness that Mr. Chambers had to bolster his self-defense claim, because without that evidence of Mr. Quiles, Mr. Sasa, Chambers has nothing to bolster his self-defense claim except his statements in which the police are accusing him of not acting in self-defense, of being the first aggressor.
Is that what the Commonwealth argued, that he was the first aggressor?
They argued it not using that legal terminology, first aggressor, but certainly throughout that closing argument, you'll see, Your Honor, that the Commonwealth is constantly suggesting that Mr. Chambers was not entitled to a self-defense claim, that he got fed up with Mr. Quiles accusing him of stealing his drugs, and finally just picked up the knife himself. And
not entitled to the self-defense claim because he was the first aggressor? Is that what they argued, or is that what
the Commonwealth essentially is arguing, that Anthony Chambers was the first aggressor?
So it was more not entitled to acquittal on the basis of lawful self-defense, whatever might be the case in terms of excessive use of force and self. He was only charged with manslaughter, so we're really talking about the question of manslaughter versus lawful use of force and self-defense, therefore acquittal, right?
Yes. The Commonwealth did not argue that it was an excessive use of self-defense, use of force and self-defense. That was not the argument. It was an argument.
But it was obviously focused on pure lawful self-defense.
Pure lawful self-defense. And this adjutant evidence, I would suggest, it goes straight to the heart of the defendant's claim that he was acting in self-defense. And this is the purpose of Commonwealth versus adjutant, that he's entitled, within the judge's discretion, to bring the testimony of a witness who can testify to violent prior conduct of the victim. And the reason is to bolster his self-defense claim.
Can I just ask you one other question? What was the theory of involuntary manslaughter? I mean, I know that's what the jury found, but I didn't quite get the theory.
That is what the jury found. That is not what was argued. It was not argued on an involuntary manslaughter theory. It was argued on a voluntary manslaughter theory. No one mentioned involuntary manslaughter until the jury
But the judge
instructions.
must have given a charge on it.
She instructed on involuntary manslaughter, yes. She instructed on both theories of manslaughter, voluntary and involuntary manslaughter, but the parties did not argue involuntary manslaughter. They argued, the Commonwealth argued manslaughter, defense argued, this is pure self-defense, give me an acquittal.
What was the theory of voluntary manslaughter?
I would presume that the theory was that it was sudden combat or heat of passion, that Mr. Chambers became angry, picked up the knife, and attacked Mr. Keeley's. And that would be, I believe that was the
But
Commonwealth's
distinctly
theory.
not excessive force in self-defense.
I've reviewed the Commonwealth's closing arguments, and they did not argue excessive force.
Counsel will have to keep it there. Thank you very much.
Thank you very much, Your Honors.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Ian Pollenbaum for the Commonwealth. The lead appellate attorney on this case in the appeals court, Ms. Sachs, had an unexpected absence today. I did have this case from arrest and grand jury all the way through trial, so I hope I'm well
Not
enough
on appeal.
versed in it. And I am perfectly comfortable arguing to this court that there was neither evidence nor argument, either explicit or by implication or by insinuation, that Anthony Chambers was the first aggressor in this case.
Well, how do you mean first aggressor? And, you know, Justice Botsford suggested the two different meanings, and it seems to me that we're laboring under the conflation of those two things, because it does seem to me that your argument was that he was the one who first used lethal force, or that he attacked the victim. But if that's the sense in which we're using first aggressor, or are we using it in the sense of who started the fight?
Who started the fight, Your Honor? And there is a clear distinction, because who started the fight really was never in dispute. Although the Judge Quinlan, declined to give an instruction telling the jury to
Why
find
didn't you
that.
just concede that?
Well, I think by not arguing that, it's effectively conceded, Your Honor.
Well, but the jury doesn't know that.
Well, but there's nothing from which the jury could find that anybody other than Mr. Keeley started the physical confrontation. Remember, it's not just Anthony Chambers' statement after the fact to the police when he's arrested. It's the evidence that the jury heard leading up to it that Mr. Keeley he started off as the more verbally aggressive one in contrast to the calm and even dismissive Chambers. And don't forget about the 911 calls, two of them, in which Mr. Chambers specifically calls the police asking for help, saying, Mr. Keeley is read as threatening me. And in the second 911 call, which the jury heard, there are sounds from which a jury could infer that there's some kind of physical accosting going on by Mr. Keeley while Mr. Chambers is on the phone.
But isn't that the very thing that you try to undermine and say that it wasn't, you know, why would you believe that? Why would you, you know, in closing you're saying this is just the defendant's claim of being in desperate fear for his own life. He tried to alert the police immediately that he was the one who was attacked. How does that square with the evidence of what was said and what he did? Chambers is not the victim or a victim. You know, does it even make sense to you that there's not a scratch on this man? I mean,
Well, Gaynor, I guess, is still the lead case in this evolving area case where this court declined to review the appeals court.
well, there it was pretty clear.
Well, but Gaynor also drew a clear distinction in terms of how this is analyzed between who started it and who escalated it and used lethal force. That you can't conflate the issue of who started it with the issue of the three prongs of self-defense. That something that's relevant to the issue of who started it, if that's a live issue, which Commonwealth contends it was not by the end of the trial. Something that's relevant solely on that issue, as so-called adjutant evidence is not relevant on the issue of whether that then creates the requisite level of fear. In other words, you can't use adjutant evidence of prior violence to support a claim that the victim's conduct put the defendant in fear of death or serious bodily injury. You cannot use it to support an argument that he exhausted all means to avoid conduct, and you cannot use it to support an argument that he only used a proportional amount of force. They're two separate inquiries. The Commonwealth never, either by insinuation, as the dissent put it, or by implication, much less by any direct statement, ever said anything in closing approaching that Mr. Chambers is the one who started the fight.
Who pulled the knife first?
That we don't know, Your Honor, but that's still a separate issue from who initiated the physical confrontation.
So when you say the physical confrontation, what do you mean? You mean blows with the fist or what?
Blows with the fist, whatever happened on that 911 call, whatever
But
happened.
we don't know what happened, and we know that Chambers said that, right, that Keelase came in with the knife from the kitchen, right?
Yes, and that was after Chambers said that Keelase had started assaulting him and then assaulted him while he was on the phone and punched him in the head.
Okay, but he's the only source of this. So, I mean, if you'd had evidence about, if you'd had Mr. Sasa testify and you'd had an instruction about it matters who the first aggressor is, given the fact that we have nobody who's seen this, it seems to me that from the jury's perspective, these two things do get conflated on the evidence in this case. That is, who started the fight and who used the knife first, or who got the knife first.
Well, but that's not how the cases. First aggressor in dispute, Your Honor, suggests has to be a live dispute, not something that people can speculate and wonder about. The only evidence on that issue was evidence from Mr. Chambers and inferentially from the 911 call that Mr. Keelase started it.
But that's precisely why you might want to have an instruction, because the presumption is that, you know, it's coming in through the police, that the defendant is not exactly the best source of information about who started a fight.
But we are still not allowed to argue, Your Honor, and the jury is not allowed to infer that if the defendant says the other guy started it and that part of it is suspect, there can neither be an inference nor an argument. Well, you have to believe the opposite. I didn't argue that. They weren't instructed on that. In fact, a standard jury instruction in almost every case, and that was given in this case, was something along the lines of, if a witness says A and you don't trust it, you can't conclude that it's B instead. You have to look elsewhere.
Well, what was the judge saying when she said there was no first aggressor issue?
Meaning that the only evidence on the issue of who started it said that Mr. Keelase did. And there was nothing the Commonwealth either presented or argued to contradict that part of the evidence, Your Honor.
Well, what didn't you make an argument about with respect to Mr. Keelase's past aggression, saying something to the effect that the only evidence you can use is the statement of the defendant, and how can you trust it?
That's only in terms of the narrow issue of, and this is the pre-adjutant defendant's state of mind, was the defendant aware of something in the victim's past that may have supported a fear for his life.
But this was after Mr. Sosa's testimony was not permitted.
Correct, Your Honor, but this referred specifically to something in the defendant's statement where first he said that he was really surprised that Mr. Keelase acted this way, implying that he would never have expected it from his friend, and then later on he adds a statement saying, actually, I've seen him F people up in the past. That was the statement, the change from I've never seen him act this way to, oh, by the way, I have seen him F somebody up in the past. My argument in response to that was that's an embellishment to support his claim of fear. That's completely separate from the issue of the adjutant evidence that was offered and then excluded. And I hope the distinction in the way I've tried to articulate it is clear, because adjutant evidence has to do with when there's a live dispute on first aggressor. Something from the past can come in even if the defendant is not aware of it at all. In this case, that comment, Justice Link, that you mentioned, that had to do with the defendant making a claim about his own state of mind.
If I can turn you to another issue, was Mr. Chambers residing in this apartment?
He was, I guess the colloquial way would be that he was crashing there, Your Honor, in the sense that Mr. Curvels allowed Mr. Chambers, who was more or less homeless, bouncing around, to stay there, and Mr. Chambers then brought Mr. Keelace along to stay there with him. So for some short period of time, they both were staying there. So, I mean, I guess if it's a question of defending one's home, I think both the defendant and the deceased had equal standing at that point as either temporary residents or guests of the apartment.
But is there a duty to retreat if you are residing there indefinitely?
I don't know the answer to that question, Your Honor, because it would be similar to something between roommates. You notice, Your Honor, that although I argued that Commonwealth had disproven all three prongs of self-defense, I think probably the weakest part of that argument was the issue of whether in that confined space he exhausted all means.
But the judge still told the jury that he has to retreat.
I don't know if Her Honor used the word retreat.
Okay,
I know there was the standard
the standard
instruction.
instruction with regard to retreat.
Yes, with regard to having to take all reasonable means to avoid combat under the circumstances, which I think would still be proper even if you considered them both residents.
Even if he resided there?
Well, the other person resided there too, Your Honor. It's not an issue of an intruder. But I don't think that the case rose or fell on the issue of retreat or exhausting all means to avoid combat. I'd suggest, and certainly was argued this way, that the credibility of the real extent of the threat to the defendant, number one, and number two, whether he only used proportional force. And remember as well, the jury found involuntary manslaughter. That suggests that they carefully considered the evidence. That suggests that they were not swayed by a subliminal or insinuated or implied notion that Mr. Chambers was the first aggressor.
Now, the jury was not given an accident instruction, correct? Even though the defendant asked for it.
I'm sorry, which instruction are you referring to?
Accident.
An accident instruction.
Oh, accident, I'm sorry. I'm a little stuffed up, Your Honor. That's correct, and I would suggest that the evidence did not support an accident instruction. The accident analysis, and this is, Figueroa has a good discussion of this, Your Honor. There's a difference between accidental act and accidental consequences.
Okay.
But
I guess my question is, if the defendant contends all I was trying to do was to grab his arm and prevent the knife from cutting me, and I did not necessarily intend to knife him, that's what happened, wouldn't that fall within the rubric of accident?
But his own statement in the light most favorable to Mr. Chambers said more than that, Your Honor. His own statement was fairly consistent at that point in saying, first he said I grabbed his hand with the knife, then he even said I grabbed the knife and pushed it or turned it or thrust it back at him. Now that puts it in the realm of an intentional action, taking the knife and pushing it or thrusting it back at him, not simply I was trying to block it or get out of the way. He talked about doing...
But he did say someplace, I grabbed him and then jerked it like that, and when all of a sudden he just fell, and I'm like, oh my God, what's going on?
Well, if you take that statement, you have to look elsewhere in that statement to see what he meant, Your Honor, by I jerked it like that. It's pretty clear from his statement that what he's saying is, I turned it back at him and pushed it back at him. And that takes it out. I would analogize it to somebody driving very fast. They don't mean to hit anybody, but they're not if they do hit somebody, they're not entitled to you would colloquially call it an accident, but they're not entitled to an accident instruction unless they can say, I didn't mean for my foot to hit the gas pedal. He is not saying, I didn't mean to push the knife back at him. He says, that's what I did.
But the jury didn't find that he intentionally, they found that he was reckless, not that he acted intentionally.
Well,
So the jury itself seemed well, the jury didn't find beyond a reasonable doubt that he intentionally stabbed him. It found that he was reckless.
Recklessness is some intentional act where you know or should know the unreasonable risk, and the unintended consequence is the death. And jury clearly found that there was no proof that he intended the consequence, hence the finding of involuntary rather than voluntary. But it was still within the proper definition of wanton and reckless conduct, which is you have to do something intentionally to set that in motion. If the court doesn't have any further questions on those two issues, I'd simply, in the last seconds, urge the court not to change the existing case law on evidence of peaceful character either.
All right, thank you very much, counsel.
Very much.